Okay, well, good morning, everyone. This is Sandy Cashmark, Executive Director, extending a welcome today from Central Minnesota Manufacturers Association and from Tri-State Manufacturers Association. CMMA and Tri-State have partnered with Minnesota Precision Manufacturing Association and several others to bring you this webinar series. Now, during these unusual times, we know you have many webinars to choose from, so we really appreciate that you've taken the time to join us today for session 2. Our intent with this series of webinars is to offer solutions for manufacturers. We want to provide content specifically geared to address challenges and to help answer questions we are hearing from manufacturers as the days and weeks go by. So thanks for joining us, and now we'll give it back to Steve Kalina.
All right, thank you, Sandy. I'm going to just give a few updates and information on just some legislative matters and things going on around the community. As you probably all know, the governor issued the shelter-in-place order that goes into effect tomorrow at 11:59 p.m. The general guidance we're giving is to review the federal CISA standards and to see if you fall under those categories, and then get letters from your essential customers to confirm that you're an essential part of your supply chain. Those letters are especially important because even if you don't necessarily meet all the specific standards or market or industries, being an essential supplier to an essential manufacturer or an essential OEM is by default makes you one of the critical manufacturing categories. So if you do have these, you should be fine to remain operational, and you do not need to apply for a waiver. However, if you're not sure if you currently meet the standard, or if you believe that you should meet the standard but you don't currently, you just need to go to DEED's website, which I've got listed here, and have your NAICS codes, and you can apply on that website. We don't know next steps or timing to that process yet, but if you do remain operational, it's essential that you do take all precautions, send everyone home that can possibly do their job from home. There's nothing exactly defining that, but the governor has explicitly stated several times, have people work at home if they can possibly work from home. So that's important to keep in mind, to keep all of your employees safe, as well as following all the CDC guidelines on keeping a safe workplace and cleanliness and keeping employees socially distanced. I would also recommend that you supply your employees with a letter that they can keep on their person at all times to ensure that they're deemed essential if anyone does inquire. This isn't required as of now, but it can't hurt. And don't hesitate to reach out if you have any questions on this process or any of the guidelines. I'm happy to help. I've been trying to keep apprised of it myself and talking to dozens of manufacturers, so I'm happy to try and give some suggestions. We all know how critical our skilled workers are, and as you've seen, needs for quarantining can become exponential in a moment's notice. So some people may not think the pandemic is as serious as it's made out to be, but the fact of the matter is that whether people are sick or not, if they can't work, we can't produce. So we can't afford to shut down essential facilities, so I implore you to do everything humanly possible to keep your employees safe and healthy. On some other legislative notes, today the Minnesota House and Senate will meet to hopefully pass another COVID-19 bill that will address assistance to child care providers, more flexibility to healthcare, and support for hourly school workers. If you did not already, one of the executive orders that the governor placed was a request for personal protective equipment inventory that was actually due yesterday, and you can see the website listed here. If you have not done so already, you should make sure to take care of that. There's some other updates. You may have already heard the numbers this morning, but there are over 3 million jobs that were lost in the past week. And of course, there's going to be more to come. It's a multitude greater than any other historical records. So I think it's important we all think outside the box to make sure we stay operational, to work with others in the industry, and to keep our employees safe. As I listed a couple of resources here, you can go to Medical Alley's website or Minnesota Chambers Grow Minnesota Initiative. Those are a couple of resources to try and find available resources if you're a company that's essential and you need more resources, labor, overflow capacity, or if you're a company that's looking to provide that. If you've got excess resources, you can use those resources as well. For the webinar recordings, I mentioned the PowerPoint's already available, but otherwise the recordings will be available on MPMA's website as listed here, as well as TSMA's website. So please make sure to check back to those anytime after this recording, or if you know of anyone else that's looking for that information. So we're going to get into the webinar here. Today we're focused on contract law. This may not be the first topic that came to mind when the outbreak became more real in Minnesota, but at this point, when more companies will be shutting down or running out of capacity, it's important to understand how dealing with existing contracts and how important it's going to be to understand the legal ramifications and how we need to communicate with our supply chain. Jeffrey Post is with Fredericks & Byron and is an expert on contract law.
Good morning, everyone. I'm Jeffrey Post at Fredericks & Byron. I'm going to talk specifically about some of the contract issues that are coming down the pike, and I think are going to rear their heads, frankly, in the next couple weeks, especially now that we have the latest order from the governor. But I know that people's legal questions far exceed the scope of what I'm going to talk about today. My firm, Fredericks & Byron, if you go to our website, fredlaw.com, has a COVID-19 dedicated page that they're constantly updating with articles in various areas from everywhere from employment to immigration in the context of COVID-19. There's about 20 different articles on there. It's going to grow. I think today there'll be a lot added now that the bills at least pass the Senate and we get a sense of the text. So a little bit about my background. I graduated from law school at the University of Minnesota. I've been practicing about 25 years. My practice focuses on manufacturers and supply chain issues. I deal with supply chain issues both domestically and internationally. I'm a litigator, but I co-chair our commercial law group, which is a combination of litigation and transactional attorneys that concentrate on serving manufacturers. So that's a little bit of my background. Why don't we go, oh, one more, I have to give the standard legal proviso. I'm just going to give you a general legal overview. What I'm telling you doesn't form an attorney-client relationship, and it should not be considered legal advice for a couple reasons. One, I represent a wide variety of clients, and I would hate to give legal advice in conflict with one of my clients inadvertently. And secondly, these issues are really decided at a very detailed level. So I can give you the general principles that I think will be a guide in navigating these tricky issues. But I would encourage you to consult with counsel on the specifics. So that being said, I'm going to go to our overview of the substance of the presentation. The next slide, please. So the topics of today, oh, back one, please, Steve. So the topics I'm going to cover today are force majeure clauses, commercial impracticability under Minnesota statute 336-2615, frustration of purpose, and then the right of adequate assurance of performance. And all these sort of are fancy legal names. To answer the question, do I have to keep performing, and do my suppliers and customers have to keep performing? And if I have to keep performing, what can I do to make sure I get paid? And I'm going to cover it in the context of legal topics, but I really do want to focus on the practical aspects of this. So what I was saying when I left off is really that these are sort of fancy legal names that really deal with the concept of whether you and your suppliers and customers need to keep performing, and if you're going to keep performing, what you can do to get paid. And so the first topic I want to discuss are force majeure clauses, and those are clauses in contracts that excuse performance based on the occurrence of certain events. And usually the events are covered are things like war, government regulation, epidemics, other acts of God, excuse me. Some events that are usually not covered, but can be depending on the language in the clause, are labor disputes, changes in product market price, increase in the cost of production inputs. So one thing I'll mention on this, unless your contract with either your supplier or customers has a clause like this, if it's in a contract or if it's in the purchase order, then the clauses come into play. If the clauses aren't in there, they don't come into play. One of the things, though, that the Chinese government is doing, and I'm not sure how widespread it is so far, but I've read, is that they're issuing Chinese manufacturers letters that indicate that force majeure was invoked. And the idea is that the Chinese manufacturers could evade performance. Whether that's valid or not, frankly, will depend on your individual contract. But it's an issue to be aware of. Could I have the next slide, please? So the limitations on force majeure clauses, the clause has to be in the contract, if I mentioned. If you don't have a clause in your purchase orders or contract, it can't be invoked. The clauses are generally narrowly interpreted. Courts want to enforce contracts. The event must be unforeseen and not in the control of the parties. Some clauses require that the triggering party give notice within a defined period. So you have to give notice within 7 days of the force majeure clause. And some clauses may not completely excuse performance. They may just suspend performance. Again, that depends on the language of the clause. So that's force majeure clauses. It may not apply, frankly, to sort of daily operations that you're doing phone orders or you're doing just sort of simple purchase orders. But I do think, especially with regard to Chinese suppliers, that it's going to be an issue. If we could have the next slide, please. So commercial impracticability, this is something somewhat similar to force majeure. It applies to every contract for the sales of goods under Minnesota Statute 336-2615. And every state in the union has adopted this, and even the International Treaty of Sales has sort of a similar provision. And this law applies regardless of whether or not it's in the contract or even whether you have a written contract. It's just part of the law of sales in Minnesota. And it applies where there's a non-occurrence of a condition that was a basic assumption of the contract, which makes performance impractical, or where there's good faith compliance with the government regulation. And that second part is really critical in the current context, because if you are shut down as a result of a government order, you have an excellent basis to claim the protection of this clause. Under commercial impracticability, it doesn't have to be impossible for you to perform, merely impractical. And finally, this clause, this provision of Minnesota law allows you to delay or even not deliver in whole, in part. So this is probably the clause that's going to come most into play in the current environment. If we could have the next slide, please. So these are some of the limitations on the doctrine of commercial impracticability. One, the non-occurrence of condition cannot be foreseeable or in the control of either party. Classic examples of the clause are not applying or overbooking orders or the partial failure of a component supply. And so what's that mean in the context of the way things are now? Let's say that you booked orders for customers in December before this was on the radar, or in early January before anyone understood the seriousness of the crisis. Likely for those orders, to the extent that you're not able to get components now, you're probably be able to invoke the protection of the statute. But now if you took a bunch of orders knowing that your critical suppliers are shut down, you wouldn't have the protection of this clause, because it would frankly be foreseeable that you may not be able to get supply. So what that says is that you need to understand your supply chain in the current environment as you're booking orders. And I will say too, look, I understand, and my hope is that in this current environment, lawyers aren't going to be needed, that you have good relationships with your suppliers and your customers, that you can work through these issues in a cooperative manner. But again, I'm just trying to provide you with some of the legal framework in case a customer or a supplier raises these issues, so you can at least spot the issue and make somewhat of a judgment, and then if necessary, turn to legal counsel. Another limitation on the doctrine of commercial impracticability is that you have to provide seasonable notice to the other party that either you're going to delay delivery, or that you're only going to deliver part or none of the units. In Minnesota, slightly more than 30 days has been held to be a seasonable time. I wouldn't go much beyond that. Again, to the extent that you're giving notice, it doesn't have to be anything formal. It can be in the form of an email, but I would say it helps to have something in writing, so you don't get into a he said, she said, she said, he said dispute about whether there was notice given. Another limitation on the doctrine of commercial impracticability is that where a seller's capacity to perform is only partially impeded, so you have enough inventory of components to partially assemble product for your end user customers, you have to allocate the goods in a fair and reasonable manner across customers. So what's that mean? Under Minnesota law, it doesn't mean that your customers have to have a contract with you. If they're regular customers, you're entitled to allocate product to them, even if there's not a formal purchase order. You fairly. What I also would say is I think you're going to be protected that you're going to allocate most of your supply to a particular customer. If that customer is providing essential services under the governor's order, I think you're going to be protected from any legal liability in that event. So next slide, please.
Sorry, I'm not sure why it's delaying.
So frustration of purpose is a doctrine that's fairly similar to commercial impracticability. It applies in both contracts for goods and contracts for services. One difference is that only one party's principal purpose needs to be frustrated. I mean, usually when you would have this doctrine applied, it would be applied in the context of someone has a factory burned down or something, then they would be allowed out. In the current context, frankly, if you're forced to close down and can't perform, you would have a strong argument for frustration of purpose, or to the extent that your customers close down or your suppliers are closed down, you would have a strong argument. But the law in Minnesota is more developed around commercial impracticability, and it's frankly more predictable, and you'll get more reliable legal advice under that doctrine. Next slide, please. So some limitations on frustration of purpose. Again, this is a common theme. The non-occurrence of the event cannot be a fault of one of the parties. It has to be something that's outside the control of the parties. Changes in market price do not trigger frustration of purpose. When you have a fixed price contract, and if the price of your components goes way up and you can't be profitable any longer, that unfortunately doesn't trigger frustration of purpose. That's just part of the allocation of the economic risk under the contract. And frankly, that same issue applies in impracticability. Generally, changes in market conditions on either the supply or the customer end don't trigger the doctrine. The ability to claim frustration of purpose can be limited by the contract. If there's limitations in the contract that preclude it, you have the right to contract it away. Finally, big difference between frustration of purpose and commercial impracticability is frustration of purpose only provides for cancellation. Under commercial impracticability, you don't have to cancel the contract, you can delay delivery. So, next slide, please. So what do you do in the situation where you're concerned, you have a customer who may be shut down, you're concerned about getting paid, you're concerned about whether you deliver? Under Minnesota law, Uniform Commercial Statute Section 336-2609, you have the right to ask for adequate assurance of performance. And you have that right when there's reasonable grounds for insecurity. You can ask the other party in writing for adequate assurance that they're going to perform. And that assurance can be many things. You can say, look, we need adequate insurance in the sense that we need a partial payment or we need a letter of credit. You have the right, if you have reasonable grounds for insecurity, to do that. The receiving party must provide that assurance within a commercially reasonable time. It can't exceed 30 days. It can be shorter if that's reasonable. In the sort of world of just-in-time inventories, it's not hard to imagine that the period for adequate assurance of performance could be shorter than 30 days. Next slide, please. So some limitations on adequate assurance of performance. First of all, you have to have reasonable grounds for insecurity. In the current environment, certainly, the fact that someone may be shut down would probably create that. Another thing I would mention, and people generally aren't aware of this, under the Uniform Commercial Code, every contract, every purchase order is considered a separate contract. So technically, if someone hasn't paid you for a previous contract, you can't cancel current or future contracts with them because every contract's separate and they haven't breached the current or future contracts. But what you can do is say, look, because you haven't paid us, we have commercially reasonable grounds for finding that there is that we have right to adequate assurance, and we're going to request that before we deliver that you pay any past due invoices. And so this statute is a tool. One of the things, though, you need to be careful about invoking it. You need to make sure that you have good counsel, because if you invoke it and you're wrong, then you have breached the contract. And so you need to, this is an area where it definitely helps to get good legal. So next slide. That's just my contact information. If you have more specific questions, feel free to reach out to me. I can run a conflict check and maybe give you a little bit more specific advice, but I wanted to leave plenty of time for any questions that the group has, and it's 11 o'clock now, so I would open it up to questions.
All right, yeah, if you've got any questions, feel free to use the chat function on the GoToMeeting screen, and then we can read them off to Jeff to answer. So Jeff, one thing I have a question on, we're trying to help manufacturers figure out how to better partner with each other. If I've got a shop that's an essential shop and I'm overloaded with work and maybe losing some of my employees to quarantines, but then a shop down the road is maybe not doing as essential work, and maybe their workload is kind of shut down on them. What are the things you think we should be careful about as far as exchanging workload, exchanging employees? I mean, if it's work that's under contract with our customer base, in this day and time when everybody's just trying to stay functioning and figure out how to stay operational, what do you think the smart way is to address that without just abiding by the contract that might say you're not allowed to do it?
So if I understand your question, the idea is that one shop shut down because it isn't performing essential services, another manufacturer is open because they are, and so you want to do you want to shift the contracts to the open manufacturer, or do you just want to shift employees?
In general, trying to balance the resources, so whether it's labor or the actual work itself, but of course either could be under contract.
So if you're going to share employees, that raises all sorts of potential issues, and you would probably want some written agreement in place how that's going to shake out for as far as a work comp perspective and a liability perspective, but it doesn't have to be anything elaborate, but you would want to do something like that. As far as shifting contracts, you can generally do that unless there's a no assignment clause in the contract. And even if there is a no assignment clause, you can certainly reach out to your customer, because I think most customers, absent some highly technical manufacturing where they're relying on your particular expertise, would much rather have the work performed than the work not performed. And so if there is a no assignment, approach your customer and see if you can get written permission to do that. If there's not a no assignment clause, you have the legal right to assign that contract to another manufacturer. Again, it would make some sense to have some written agreement around what that means, because if you assign a contract, you're still on the hook for the performance of the product. It is the original manufacturer who had the contract, and so you have all the warranty and other legal liability to the end user customer on that.
Sure, thanks. I do have one question that came in through the chat log. Would it be a good idea to confirm new orders with a commercial impracticability contingency statement?
It would be. I mean, I think for years, we as lawyers didn't worry about force majeure clauses. That's, we lived in a world where that stuff never happens, or happens so infrequently. But yeah, you can definitely include some language in your contracts, and it's a good idea to say, you don't have to for commercial impracticability. It applies regardless. But if you have some express language, you can protect yourself for sure. You're always allowed, in contract language is enforceable, that protects you. So you could say something to the extent that if we lose suppliers, we're entitled to suspend performance. Spilling that out gives you better protection than just relying on the general legal principles. And you can have, frankly, I didn't mention it, but even you can have price changes clause or adverse materially adverse changes in condition clauses. So let's say the prices of components go up radically. You could have a out in the contract that provides for that and has some sort of pricing mechanism that increases the end user price in that circumstance. Again, these are all things that can be drafted for. Maybe in the last 10 or 15 years, we've got a little bit complacent about those things. But in an age, frankly, even before the coronavirus update, with all the tariff issues that I think are frankly not going away anytime soon, it makes sense to draft for that sort of things, because supply chains just aren't as reliable as they used to be, or if they're reliable, your price structure and the supply chains aren't as reliable as they used to be. So it's definitely something to think about, and maybe at some point we'll post some sort of model clauses potentially on the Frederickson website. If we do that, we're scrambling too to try to serve clients, but if we do that, I'll let Steve know, and he can certainly reach out to the members to let you know it's posted on our COVID-19 page.
All right, well, before I wrap up, are there any other questions anyone would like to pose to Jeff? All right, well, I want to thank our presenter, Jeff Post from Frederickson and Byron, and thank you to all of our attendees and our industry partners that helped put this on today. Our next webinar is going to be on Tuesday, March 31st at 10:30 a.m. on supply chain management, and that's going to be some specific solutions for manufacturers on how to address your supply chain, not only the operations of it, but their protocols, and making sure that we're all working together, and again, trying to be creative about supply chain solutions. I want to wish you all, yourselves and your families and your work families, all the best. I hope you all take care and stay healthy and stay busy and have yourself a good weekend. Thank you all very much. Take care.